trial, as well as a motion requesting a list of any other dates and persons involved in any other ex parte communications throughout the time frame of this trial. And it's also a motion for mistrial based upon both judicial and prosecutorial misconduct. So, no retrial. So, we got through a lot of this already. And I believe we were here. Let me zoom this in. And before we do that, I do also want to thank you guys. You guys are being so supportive today, and I appreciate you. I'm still getting used to toggling between super chats and the screens and making sure I don't miss you guys. But yeah, Victor, I think I may have covered this, but they wouldn't need immunity until after they knew about the fifth. So why did they communicate? Why didn't they communicate with Melnick? And then Victor, this made me laugh reading your name. But you had said while we were watching the video that y'all remember the state didn't want Woody's name mentioned as the next witness. But the defense baited the judge into asking if he would be testifying. And Dre has really summed up this point a few different times, but that's a good possibility that that's why Melnick interjected himself, according to the state, Thursday evening. They're acting like it just came out of nowhere for no reason. But the timeline is there. It's kind of self-explanatory. Garrett says new team lineups, DA Glanville and Judge Love. Okay, well, what? They're switching the roles. Can you imagine Judge Glanville leading a cross-examination or direct examination even? I think he'd just get bored. He'd call a break in the middle of his own witness testifying. Thanks for becoming a member, Victor. Peguardo says, I think the first emails were regarding the bond conditions from another case. Yep. So it might have been from another case. I'll have to double check that. It could be from another case because Woody had, several things going on. But still at the same time, that's still a pretty recent correspondence. It's in the same district. It's in the same court system. They could have looked. But if that's accurate, it's always good to be more accurate and get the details there. And guess who the judge was? Oh my God, wait. So the judge for Woody's other case? Was it Krause? Was it Krause? I see the K. And Garrett says Melnick was his attorney for a bond issue with Judge Krause. So this is the same. Guys, I don't know. I'm a mixed bag on Judge Krause. I really think from the orders that she's looking for someone to give her the argument. Give me the argument, give me the things that I need, and if it's meritorious, I'll fight in favor of that. But I do understand corruption runs deep, and I do understand that, she works under Judge Glanville technically. They could be friends. And even if someone doesn't mean to be impartial, they might not realize that they could be impartial. And I guess also on the flip side, someone could try to overcorrect an appearance of impartiality and kind of favor the other side to correct for it. So I have to wait and see everything with Rachel Krause play out personally. My optimism lies in, the comfort from the Supreme Court saying, hey, if you don't like the resolution, after the Superior Court judge, whoever gets to look at it, looks at this motion to recuse Judge Glanville. If you don't like the resolution, just come back and see us. Just come see us. That's really where my comfort lies. And then Rod Factor with the shirt that says ATL Ho. Thank you so much for the $49.99 super chat. 80 Love makes me cringe. Every time she speaks, I hope this case causes Fani Willis to lose her re-election. I think it's hard to get rid of an incumbent no matter what they do. But I understand. You guys let me know your thoughts in the chat. If you think what we're seeing going on, we're going to keep it to the scope of the YSL trial. But the promises that DA Fani Willis came into office with, when it came to indictments and doing things that are better for the community, do you think that this is the best way to accomplish that mission statement, those campaign goals? Because if that's some of the reason that people voted for her, it could be a very big problem for her reelection. It depends on what platform they care about the most. And I appreciate your support for the channel, Rod. If you guys haven't tuned in to some of the smaller things, they're big things, but they're smaller news stories in Fulton County. The ACLU 3 different attorneys from the ACLU of Georgia and an organization called Barred Business. They filed a petition for a writ of mandamus back in March of this year. I think it was March 21st. They were taking issue with the fact that there is a very high number of people sitting in Fulton County jails without an indictment. And according to code, if they're there for 45 days sitting without indictment, it's time to notify a judge, send a note to the judge and say, look, this guy still doesn't have an indictment. We need to get it on the calendar to have a bond hearing. It's required. That's what the DA's office must do. And the ACLU sent records requests to the DA's office. And they said, look, we're looking for copies of notes sent for these people that have been sitting there for more than 45 days, really more than 90, without an indictment. Did you notify the court as you're supposed to that they need to have a bond hearing scheduled? They tried twice, and both times, we don't have the responsive documents. What does that mean? We don't have the responsive documents for a note that we're supposed to be sending. Might it be that you're not actually sending the thing that you're supposed to be sending? So they filed this petition for a writ of mandamus because they want a higher court to order Fani Willis to do what she's required to do. She platformed on this, reducing people sitting in prison without indictments. She has an entire pre-indictment diversion program that she made a PowerPoint presentation to help secure an additional budget for. Like, it's crazy, 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 crazy. It's crazy. So, if that was an important part of her campaign, I don't live locally to have a pulse on what people are saying. But if that was an important campaign message that people related to, that resonated, and it compelled people to go out and vote, we would love to see more indictments diverted. We would love to see people actually brought to justice, whether that means they get convicted or they're acquitted, whatever the case may be. But stop this limbo where people are sitting and we're paying to keep them in the Rice Street jail. If that's the part of the platform that resonated with people and that's not playing out and people are becoming aware of it, I think it really could impact the election. But I don't know. I don't have a pulse. I don't have a pulse on it. I know she won her primary though. So, but I appreciate you again. And I also appreciate the opportunity to go off on a tangent because I really, really dislike the idea of someone being held in custody indefinitely without just cause. Can you think of a worse violation of your rights than being stuck for more than 45 days, more than 90 days, sometimes more than a year? Someone was stuck for like 436 days, and they actually had a hearing in front of Judge Glanville about it. This is in September of 2023. And Judge Glanville is like, well, now that you told me, I can do something about it. So, maybe we'll start holding courts on Saturdays and start moving this court calendar. We'll start moving things through. Do you guys think that ever happened if they had to file this petition for a writ of mandamus in March of 2024? Judge Glanville said, we'll speed up the court calendar. We'll move things faster. It was Judge Glanville that made the promise. So, but let's get back over to the Steele motion, you guys. And shout out also, so Garrett was saying Woody was on TLA and said Krause violated his civil rights. And that was talking about, they didn't want to give him a ankle bracelet either, right? They were saying that they didn't even try to offer him one. So maybe it was Melnick that asked, like, can you give him an ankle bracelet? And then they denied it. Guys, that was good too. So if you go to the lead attorney's stream yesterday and scrub through, use the timeline, look for when Woody pops up on the screen, because Woody spoke a lot about prior cases in Fulton County. He also spoke about a case that went up to the feds, but it was the state that provided the case file, and they turned it over to the feds. And part of that case file involved what Woody's saying was video footage that was clearly chopped up, missing pieces. So really, really, really lots of details that if I'm trying to repeat them, I wouldn't get right. So definitely shout out to that stream. It was long. It was like a 7-hour stream. So you'll want to look for Woody if you want to see that part. And then Dante with the straight up $5. I appreciate you. And I'm going to butcher your last name. Bagnasco. I need a hooked on phonics for name pronunciations. And then Albert Edens is now a member. Welcome. Make sure you choose your Mario Kart racer. You have special emojis now. But this BrIan Steele filing, we were just talking about. She shared this demonstrative aid during her opening statement. After she turned over last minute the demonstrative aid that she was supposed to use, she turned it over at the last minute as she's supposed to, and then still showed a different demonstrative aid. During opening statements, like a couple minutes in, BrIan Steele moves for a mistrial right then and there because of that. And then during the same opening statement, Lawyer Love once again defies another court order, introducing to the jury that undersigned counsel had represented other people charged in the case. Because up on a PowerPoint presentation, this thing that it was like 4 slides and then it became 60, they have the attorney's name with the person they represented on this PowerPoint slide while they're showing it to the jury in opening statements. So right then and there, they're like, oh, we object. But again, no consequences were meted out by this court. Then Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury that witness Mr. Bean was taken to the hospital. They called a bench conference during this time that this was happening. This was back in the spring. So this is a few months ago already. Love was saying, we have evidence on her table that proves these defense attorneys are lying, that they're fabricating evidence, and that Mr. Bean never went to Grady Hospital on September 11th, 2013. Lawyer Love's allegations against undersigned counsel were proven beyond any doubt to be totally and knowingly false. Yet the court did not admonish Lawyer Love at all for falsely accusing another member of the bar of being untruthful. Now, this is great. I'm glad we stopped reading this to go over to Love's argument. Because what do we see Love say in her argument? There was only one instance where anyone in this court wagged a finger over at the defense counsel. But right here, going all the way back to March, we have a pretty clear example of the prosecution accusing the defense of fabricating evidence. So already, this filing that Steele slipped in through the door today gives extra examples contrary to Love's assertion. It only happened one time. Then over Mr. Williams' objection, when the state was attempting to introduce the January 26, 2015 social media posting from Cohen's ID Garlington, his account about the testimony of Detective Gaither, Lawyer Love told the court that only Mr. Williams' voice could be heard on this video and audio, except for one other voice saying words like, yeah, in the background. Undersigned counsel told the court that Lawyer Love was incorrect and that several persons' voices were audible in the social media posting. Lawyer Love continued to falsely accuse undersigned counsel of misrepresenting facts to the court. Of course, Lawyer Love was proven... Of course, Lawyer Love was proven to be untruthful in her false allegations of wrongdoing against undersigned counsel. Although it was objectively proven that Lawyer Love falsely accused another member of the bar of misconduct and lying to the court did nothing to admonish Lawyer Love. This pattern of permitting prosecutorial misconduct illustrates that the court wrongfully favors Lawyers Love and the state of Georgia in this case. Maybe we'll watch this clip too. This was a bunch of back and forth, but since they give us the timestamps here, maybe we can look at that after we're done reading this, because that was a day too. On Thursday, June 6, 2024, as well as Friday, June 7th, 2024, Lawyer Love falsely accused undersigned counsel of purposely extracting and tampering with jail records of Mr. Copeland. This was another knowing, malicious, false allegation by Lawyer Love. The court remained mute and failed to admonish Lawyer Love. And we can watch some of the June 6th clips here too, if you guys want. You guys let me know in the chat if you do want to watch any of these clips after. We're not going to keep beating June 7th over the head. On Friday, June 7th, Lawyer Love falsely accused counsel for Mr. Copeland of violating his ethical duty to his client. The court remained silent while Lawyer Love hurled more false allegations. In the jury's presence on separate occasions, the court wrongly accused undersigned counsel of being, quote, unprofessional, as well as, quote, unprepared. Both allegations are completely false, yet the court's bias is so deep that the court refused to instruct the jury that the court's declaration was completely wrong on both occasions, as undersigned counsel was neither unprofessional nor unprepared. Now, what's interesting is at the beginning of this, and this is nice, this is a shorter filing from BrIan Steele than what we normally see. But because it's short, you can keep the bullet points closer to the forefront as we're going through it. So in this paragraph here, well, they're criticizing me for being unprepared, but the very first issue I raise in this filing is you went from like a 4 to 6 page presentation to like 50, 60 slides, and then you're going to call me unprepared when you have a duty to provide any demonstratives ahead of time. You're making it so we can't be prepared. And then in open court, you're calling us unprepared in front of my client and in front of the jury. And then this court's overly prejudicial and improper conduct towards Mr. Williams and or his counsel, and its refusal to instruct the jury to disregard these impermissible and false allegations, as well as the court's failure to apologize for its baseless claims, proves bias for the state and prejudice against Mr. Williams and or his counsel. And it'd be a little bit different, guys, if Judge Glanville treated the state the same way. If you guys have watched a lot of the trial, have you seen moments where, on the flip side, Judge Glanville has done the same thing to the state? Because that's where it becomes an issue. A judge has discretion. A judge isn't going to have, a strict guideline of how to rule on every single objection made, for example. But they have a window of discretion that they can use. But if the needle always leans in a direction that favors one party, now it becomes a more questionable issue. These above few examples raise reasonable questions concerning the court's partiality and bias against Mr. Williams and his counsel's efforts to obtain a fair trial and a fair tribunal without prosecutorial misconduct. This court's impartiality is objectively questioned, and the court must be recused. So see, for example, and they cite Johnson v. State. This court has falsely and wrongly accused undersigned counsel of being unprofessional and unprepared in front of the jury. Neither claim has any modicum of truth. The prosecutor sat silent as the court wrongfully and falsely accused undersigned counsel of improper conduct in front of the jury, all prejudicing Mr. Williams. The court has violated its duty of neutrality, impartiality, that it was even sworn to undertake. Even knowing that the court has falsely accused undersigned counsel of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper, highly prejudicial comments. This conduct shows that the court is biased against Mr. Williams and or his counsel and favors the state as no unbiased judge would not correct such a serious misstatement made in front of the jury. The bias of the court is objectively proven. And then, to date, the court has done absolutely nothing to stop Lawyer Love from continued misrepresentations, abuse of others, and false allegations. Instead, on one occasion, the court speaks in generalities and reminds both sides to be professional. And we watched that. That was recent. Because remember, when they tried to call it out, they're like, no, this has been done by both sides. It's been both sides. And here, Steele says that this is not a both sides issue. This is a one-sided issue. And for clarification, we also put a 1 in parentheses. A one-sided issue resulting in prejudice to Mr. Williams and a violation of his constitutional right to a fair trial. Mr. Williams languishes in jail without bond since arrest on May 9th, 2022. Mr. Williams has been and is being denied his constitutional right to due process, fair tribunal, and a fair trial based upon prosecutorial and judicial misconduct. The court has exhibited a pattern of bias in favor of the state and against Mr. Williams and or his counsel, and the court has failed to admonish Lawyer Love to prevent her past and continuous misconduct. This failure to act by the court has emboldened Lawyer Love to persist in engaging in misconduct. And then now we're going to get some of the same arguments we saw yesterday, you guys, but the court has effectively joined the prosecution team. And who was joking in the chat that they're switching roles? It's going to be Judge Love and DA Glanville. So they did this by permitting Lawyer Love to defy court orders without consequence. And they gave one example here, right? You've got to give examples. You've got to show what you're saying. So one of those examples was, hey, there was a court order in place that demonstratives must be provided to both sides. If you have a demonstrative, you got to provide it to us. Love didn't do that. The court has imposed absolutely no sanctions to stop or deter this prosecutorial misconduct. As a result, Mr. Williams has not received a constitutionally mandated fair trial, does not have a fair tribunal, and his due process rights have been repeatedly violated because of the misconduct of the prosecution and the judge. Because the state has blatantly violated Mr. Williams' rights and goaded Mr. Williams into making motions. We've seen many motions for mistrial, all of which have been denied. The above few examples are egregious and cast a dark, ugly stain onto Georgia's justice system. The below further captures the violation of laws that lawyers Love and Hilton and the court display herein. And this is where we're going to get the argument about the immunity and the ex parte. So on Monday, June 10th, we already know, you guys, the court is in there too. It's the judge and it's lawyers Love and Hilton, and they have this ex parte meeting with previously sworn witness Mr. Copeland, so he's already sworn in, for whom an order of use immunity had been issued on Friday, June 7th, 2024. No notice of this ex parte meeting was provided to any attorney for any of the accused on trial. In fact, the accused and their counsel were wholly unaware that the Star Chamber meeting was occurring or had occurred until well after the fact. Mr. Copeland had previously been called to testify on Friday, and he asserted his Fifth Amendment rights in front of the jury, and as such, he was held in contempt, and he was incarcerated over the weekend until such time as he agreed to testify, pursuant to the order granting use immunity. Once undersigned counsel confronted the court with a motion as to why the court held this impermissible ex parte on Monday. And this is where it becomes a problem, because you have the chance to tell us. You have the chance to promptly disclose. But what happens? Even though they eventually admit that this meeting had in fact occurred this morning, this admission only occurred after undersigned counsel revealed, based upon information and belief, that this impermissible illegal meeting occurred. It wasn't disclosed. It was, exposed, if you will. Undersigned counsel proffered that statements were made to and in Mr. Copeland's presence by the court and or lawyers Love and Hilton, all acting in concert, asserting that Mr. Melnick failed to represent Mr. Copeland's interests, and 2, explaining the amount of time that Mr. Copeland would be held in custody unless he testified, as urged by lawyers Love and Hilton and the court. Also on June 10th, the court denied undersigned counsel's request for the transcript. And they also denied undersigned counsel's timely motion for mistrial based upon, but not limited to, Mr. Williams' federal and Georgia constitutional and statutory rights. And we know what those are at this point, guys. Fair trial, fair tribunal, ethical prosecution, all the things. And the right to be present at every critical stage of the proceedings. But instead, the court decided to hold me, BrIan Steele, in contempt and ordered me to spend 20 days in jail, despite the assertion of valid privileges in declining to answer the court's demand to reveal the supposed source of information about the ex parte meeting. So, in the afternoon of Monday, June 10th, Love and Hilton sat mute and permitted this travesty of justice. Lawyer Love argued, hold on, guys. I can't read the same thing over and over anymore, BrIan Steele. So later, Lawyer Love argued that ex parte conversation with sworn witness Copeland was ethical, just, and proper. And I think she argued that today in her response, despite it violating multiple constitutional provisions, judicial canons, and rules of professional responsibility. And then furthermore, Mr. Williams' request. So this is where we want. This is why this is important, you guys. We want this mistrial. We want a fair trial. And at this point, you need to tell us, what are these other persons that you may have had an ex parte meeting with? And we get this little if any. But this question, we're asking for it because we expect that there's more. So Mr. Williams requests a list of persons involved, the topic of the same, and a transcript of all ex parte meetings conducted by the court involving anything to do with this case or trial. Additionally, Mr. Williams also moves that any document that is filed under seal be reviewed by a neutral judicial officer to determine whether the same needs to be unsealed and shared with Mr. Williams. So, we don't just want to know about ex parte meetings. We want to know about anything that may be under seal that you're saying there's a reason to be under seal. Because now we can't trust that. We can't trust that. Yeah, I need a comfort break, you guys. What was it? Was it June 10th? Was it that Monday that Judge Glanville started like chomping and suckering down on a cough drop or something? It was some point that the attorneys were trying to proffer their argument, and he was all up in the microphone like blah 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 blah. like of all the times he didn't take a comfort break, he just decided I'll just chomp up on the microphone. Yeah, this is a pretty big question, you guys, because in the header of this document, in the title, we're asking for other ex parte meetings. What haven't you disclosed to us? But also, there's stuff that's filed under seal. Someone else should review those things. So wherefore, and we're almost done, and we can look at some clips, you guys. Have a comfort break. It probably was a Cherry Halls. Undersigned counsel respectfully requests that Lawyer Love be barred from uttering false allegations or disparaging words. That's hilarious. Toward anyone else, I guess. I thought for a second, did you guys remember that clip? Did you guys watch the stream or see the Cuff Boys clip where he called out where Love and Hilton were fighting over the microphone? It'd be funny if they were ordered to stop doing that. But 2, Lawyer Love, conduct yourself with professionalism and in full compliance with the Georgia Rules of Professional Responsibility, which govern the conduct of lawyers in the state of Georgia, if able. And 3, a mistrial be declared based upon Lawyer Love, Lawyer Hilton, and the court's failure to protect the above stated constitutional rights, as well as Mr. Williams' right to be present, for these critical things, to confront the witness. We also want Williams to have the right to the fair tribunal, right to the fair trial, right to due process, and right to present a defense and call witnesses, including the ones we added to the witness list today. So, signs off, BrIan Steele, Keith Adams. And then is this the one for the demonstratives? Or, let's see. This is the order back from July of 2023, but finally signed off on November of 2023. So we can't mention that Steele represented another person. So talking about that Blaylock mention that was in the PowerPoint presentation during opening statements of this trial. We made it halfway, not even into opening statements. And we had a violation of a court order. So they attached that here. That's the receipt for that. And that's good timing if you ask me, Barbara. You also missed me like half choke out trying to read. And Red Bunny, don't give us the imagery. Shout out to AM and Mia Joseph becoming a member right as I choke out on stream. Thank you, Mia Joseph, for the $5 super chat. Say thanks, Kat. You're the best. Love how thorough you are. I feel like I'm not being thorough because I'm not stopping to play all these clips, these little things in the bottom. I really love some of these video clips, you guys. The June 7th one, I've played like 5 times, and it gets better every time I watch it, just to watch the district attorneys, lie. We already know what they knew the day before June 7th even started. And we know what they're going to do on June 10th. So watching June 7th is just incredibly hilarious.